Good morning, ladies and gentlemen. Thank you for joining us once again for another episode of PLA with myself, Nick from SSLR, and Bruno from Bruno Simao Attorneys. We've got one question or scenario that we'll be dealing with today, and I believe this is one that Nick is currently handling at the moment. Just a very brief three-liner for me, if not two-liner. I'll just really just give a skeleton, then Nick can dive into it, and Bruno can tell us what he thinks as well. So in short, it's basically got to do with liquidation slash sequestration. And then the person being liquidated or sequestrated is actually an attorney. And as it stands right now, there's a property that's involved, and the attorney is preventing people from obviously viewing the property or the house. Therefore, now the house, it's making it very difficult for the house to be sold, obviously. And then the question then becomes, can then an application for eviction be brought in this instance, or should maybe we look at having a go at interdict and maybe having a look at that option? Nick, maybe you can dive a little bit deeper into it and we can take it from there.
Yeah, perfect. So obviously we don't deal we haven't dealt so many times with sequestrations or liquidations on this particular channel, but it is an important part of our legal system when people get in trouble with their debtors. And unfortunately, with the difficult economic times we're sitting in, it's something that is becoming more prevalent. Now, obviously, most people would not have dealt with sequestrations or liquidations and probably don't know the process. But basically what happens is there's got to be a court application to declare someone under liquidation or sequestration, and there's a process to doing this in front of a court. Basically, anyone who has an interest in the particular proceedings is invited to come to court to sort of dispute the proceedings and try and avoid it if at all possible. But if not, and all relevant parties have been notified, then a sequestration or a liquidation can happen. Now, when this happens, obviously a person who is now in charge of the estate is appointed, by the master. And it is their job to basically wrap up the estate, find all the assets of the particular estate, and dispose of them so that creditors can get paid whatever can be paid out of the particular estate. It's very rare and impossible that your creditors are going to get paid everything in the estate. If they were going to get paid everything, there's no way you could get the sequestration or liquidation because you'd have more assets in your debt. So it's very likely in the circumstances that your creditors that go into these particular proceedings are going to get a percentage out of their rand for what the debt is in the estate. And so to do this, the person that's in charge of the estate now takes control of the assets of the estate and has to dispose of them, liquidate them, and then distribute them to the particular creditors who have proved their claim in the estate in the circumstances. Now, the difficulty with this particular question is what happens in a circumstance where the owner of the estate, so the person who has been sequestrated, generally they're going to be living in an immovable property of some kind, which they own, and obviously we all know in the process of selling properties, it's a pinnacle part of selling properties is you go view the property, you go have a look at the property and what the condition of the property is, or at the very least, you've got some nice photographs which have been taken by an estate agent or whoever's in control of the property so that you can see what you're purchasing. Sure. Purchases of immovable properties, certainly it's a very rare circumstance where they're going to purchase a property where they have absolutely no idea what the inside of that property looks like. And so the inability for purchasers to see the inside of a property for whatever reason is a really big inhibitor of sales of properties. And this can bog down a sequestration proceeding, because if the person who has been sequestrated is still sitting within the property, they are going to do their best, maybe to frustrate the proceedings and stop the executor from actually showing people. So the question comes, well, what do you do in the circumstances? I know Bruno's got a couple of views and different tactics on this.
Indeed. Oh, okay. Well, all right. So it's again, like Nick said, it's actually such an interesting field of law because one would assume obviously that a person in financial difficulties would you know, kind of what's the word? Resign themselves to the fact that, you know, they need to pay off their debts, and there's certain things that need to be done. One assumes this, but it's far from the case. So, you know, a lot of the experiences I've had with insolvencies and sequestrations have actually been very negative. As an attorney, obviously you get 10% of you know, the 100%. So 90% goes well, you only get the 10% difficulties that clients experience. But out of that 10%, you typically tend to experience people that, even if they sequestrated themselves, and we don't need to go into detail over this, but I mean, there's ways where a person can do it to themselves versus you know, forms, court processes where it's done to them. So you can be declared insolvent by somebody else, or you can declare yourself insolvent. But now let's deal with the property and people on the property. So now the insolvent is on the property. The insolvent is making life difficult. So Nick mentioned at a point, there are different options. So you can go to court and say, listen, guys, I need access to this property. So we used to do this thing called access applications, right? Why access applications are really cool is because they're less intrusive. We speak week after week over evictions, and the reality is evictions have this element of constitutional rights that have to be balanced, and it's housing. So it's not a small constitutional right where it's not that privacy is small, but the court obviously weighs housing a lot greater than privacy. So kicking somebody out of their home, rendering them homeless, if they have children, if they're old, you know, we speak about it week after week. It's not an easy process. So you land up going to court, and it ends up being delayed. The people oppose, the municipality has to get involved. They need to file reports, etc., etc., etc. Our access applications were a lot easier because you go to court and say, listen, guys, give me access to the property. Simple as that. Give me access. And yes, you know what, there's a right we're infringing, but technically speaking, we're actually entitled to this property. We have a right to it because there's liquidators, trustees, whatever you want to call it. There's specific sections in the acts that actually empower them to take control over assets. So if there's movable assets, they're allowed to take control over it. Same as properties. They're entitled to do eviction application. Nothing stops them from doing it. The only reason they don't is because the costs, there's way too many costs. Most of these estates aren't liquid. So the question then comes in, where are we getting the money? We need to sell the property to get the money to do the eviction. So we can't do the eviction before selling the property, right? So what lands up happening in these situations is you might get an access application, which is slightly cheaper. The reason why a liquidator would do this is he finds a little bit of money. He knows he can market it if he can get purchases in the house, but then he tells these purchasers, good for you, but after this is done, the eviction sits on your doorstep, or I'll do the eviction, I don't mind doing it, but there's going to be a certain exchange of funds at some point in the process where I'm going to expect you to actually cover it, but it'll get deducted from the purchase price. You can do whatever agreement you want. There's a whole bunch of ways of skinning that cat because you can contract, right? And some liquidators are open to it, right? So you buy it, do the eviction yourself, which is the case most of the time. You buy it at risk, you buy it at a low value, but then the eviction's your problem. Liquidators walk away with it, walk away from it. But I've had clients, for example, that negotiate and say, cool, I'll pay you top market, but I expect the funds that I contribute, and then you take the risk yourself. But so that's definitely an option. The access application is another way of doing it. And that's just a matter of getting purchases in the house, showing the property, and then saying, cool, this is how we're going to deal with it after the fact. So those are my quick solutions, to when I've experienced those issues, Nick.
Yeah. And I think what's important is obviously, you know, each liquidation is going to be a little bit different. Yes, the problem might sound similar in the circumstances, but really you've got to address each problem on its own sort of merit, you know, and see exactly what's happening. Remember, every estate's different, even though you're definitely dealing with, you know, the majority of your estates, you're dealing with circumstances where you're really going to get cents in a rand. And obviously a big, you know, a big thing about bringing the eviction application is the cost is going to fall somewhere, and each little bit you do there is going to, you know, bring down the ultimate cent that each individual creditor might receive in the rand. It's an important consideration, but I think what's important is the options are obviously there. And in particular, I know with the client that had approached us, sort of their view was, well, what do we do if the person that's staying in the property is the owner? What can we do against him? Because we always talk about ownership as this sort of ultimate right in a particular property. And it's the strongest right that a person has. But what needs to be remembered is at the point where sequestration falls, that property no longer vests in that particular owner. The law has seen that would be ultimately problematic because you couldn't do anything with the property. And obviously the property moves firstly to the master and then eventually to the appointed liquidators in the circumstances. So you can bring the eviction. Question of whether you do bring the eviction or do you look for an alternate solution in the circumstances, well, it really comes down to the liquidation at hand and what you're dealing with.
Yeah, absolutely. Yeah, and the bank sometimes. So just a quick one, but this really depends on the circumstance. So if it's your normal residential property, the banks typically don't want to get involved with that. Yes, they're secured creditors, they've got bonds, but they cut their losses and they go, listen, sell it for minimum this amount and let the purchaser take the risk of the eviction. But I've seen with large properties or where the debts are very big or where these guys had credit facilities that are just beyond like a little loan regarding a property, sometimes the banks actually do have to step in and try figure out how they best realize the asset in order to be able to cover the debt. But this is a completely different conversation. So there are other ways where the creditors even step in and start doing contributions, knowing that I can sell the property now, no one's going to buy it, it's going to be an issue, and I'm going to get whatever 10 bar for it, or I'm going to step in, I'm going to deal with this, I'm going to do the eviction, I'm going to do the access application, I'm going to get people into the door, but I'm going to be able to sell it for 30 bar. But again, like Nick said, depends on the insolvency, depends on the creditors, depends on the asset. Retail banks are less likely to find that than private equity financiers, private banks, certain like more specialized banks, because they deal with it differently. And it's very difficult to kind of set a tone for how they're going to address it, because each manager would want to deal with it in their own specific way. So yeah, it's just throwing that in there.
Perfect.
Right.
Cool.
Yeah.
Awesome.
Awesome. Thank you, guys. So that deals with that type of question and answer, and hopefully we wishing Nick the best when he's busy handling that one. And that's it for this week. Thank you very much for everybody for joining us, and we'll see you guys again next week.
Awesome. Thanks so much, guys.
Thanks, guys. Cheers.
Yes.